after a contract has been awarded, normally we would say that the procurement process has finished, and therefore the governance of public procurement law ends. The execution stage usually is governed, depending on the jurisdiction, by private contract law or variation of administrative law applicable to public contracts, which are differentiated from private commercial contracts. Therefore, these types of law would govern a need for contract modification. That is a situation when something needs to be changed throughout the contract's lifespan. There might be a need for price amendment, an amendment of the amount or extent of the contract, extension or reduction of the contract, or even need to change the contractual partner. Over the years, Court of Justice developed case law on contract modification, which currently is codified under Article 72. However, before we jump to the law and rules under Article 72, we should consider why there is a need to control modification of a procured contract. Why can it not be left to contractual parties to resolve whatever the amendment is needed? The problem might be illustrated by an example. Let's imagine we spend extended amount of time and resources to design a truly sustainable public procurement, incorporating green and social factors throughout the procurement process, including contract performance conditions. After the contract has been awarded, the contractor realizes that upholding the promised high standard of sustainability of the supplies will cost them too much, and therefore decides to renegotiate the procurement terms with the buyer to decrease the level of sustainability standard under the contract. If that were allowed, it would jeopardize the whole point of having procurement law in the first place. As for example, other companies, due to this before mentioned high sustainability standards that were designed in the original tender, decided not to partake in the procurement process in the first place. However, if the procurement conditions were lower, as in the renegotiated versions, these suppliers might have decided to partake in the tender and potentially even offer the winning bid. One of the main cases that is being perceived as the seminal case on contract modification is the Precitex case that gives the ground for today's regulation of Article 72. 72 includes a catalog of modifications that are allowed. These are the modifications that are foreseen under clear, precise, and unequivocal review clause, the modifications for necessary additional works, services, or supplies, modification necessary due to unforeseen circumstances. This modification ground has been used particularly extensively during COVID-19 pandemic, but also change to a contractor, change that is unsubstantial in its nature, or the so-called de minimis change, which is the modification within a stated financial limits. For all these modifications to be allowed, they need to fulfill other requirements under Article 72. These requirements vary slightly depending on in which of those exemptions you are. However, we might still group them somehow. Many of them include a monetary cap on the value of the allowed modification, ranging from 10, 15 to 50%, and also requirement prohibiting the modification for altering the overall nature of the contract. Surprisingly, the concept of overall nature of the contract has not been defined or characterized in detail in the directive or in a case law. Only Recital 109, when elaborating on contract modification due to unforeseen circumstances, states that alteration of the entire nature of procurement may consist, for example, in replacing work, supplies, or services to be procured by something different, or by fundamentally changing the type of procurements, since in such situation a hypothetical influence on the outcome may be assumed. Consequently, changing the overall nature of a contract refers to type of contract, work, service, or supply, and the subject matter of the procurement. So, for example, if we set out to procure organic free trade coffee, but then we realized that supplier was delivering us a coffee that was not organic and fair trade, in my personal opinion, that would change the nature of the contract. Article 72 also includes a catalog of prohibited modification. These are changes that would be accounted as substantial, or in other words, material changes, and follow from the conclusion of the precedent case. An amendment to a public contract during its term is material when it introduces conditions which, had they been part of the initial award procedure, would have allowed for admission of tenderers other than those initially admitted, or would have allowed for acceptance of a tender or other than the one initially accepted, or would have attracted additional participants in procurement procedures. Also, the amendment is prohibited when it extends the scope of the contract considerably. Also, when the scope is reduced considerably, as follows from the Finn-Frogner case. This can be clearly seen on the example. If the contract value from 50 million euro is reduced to 10 million, will potentially be more companies that would have the capacity to bid for a smaller version of the contract than the original one. Lastly, the modification is material when it changes economic balance of the contract in favor of the contractor in a manner that was not provided in the terms of the initial contract. Couple words on specific type of change, that is the change in contractor. The change of a contractual partner in general is considered a modification of an essential term of a contract, so a material amendment. Unless it is predicted in a clear, precise, and unequivocal review clause, it is an effect of reorganization, for example, takeover, merger, acquisition, or insolvency. At the same time, when the contractor is changed on the mentioned basis, the new contractor must fulfill the original selection criteria. Also, no other change that would alter the overall nature of the contract can be introduced. Change of the contractor must not be used also to circumvent the application of the procurement directive itself. Lastly, it is worth pointing out that not only change of the main contractor might constitute a material change. It follows from the Wall case that in some circumstances where the use of a particular subcontractor has been a decisive factor in evaluating and consequently awarding the contract, change of such a subcontractor may constitute a material change.